Hello and welcome to the Eversheds Sutherland Webcast, Cybersecurity Breaches and the Risks to Fiduciaries under ERISA. If you have questions during the webcast, submit them via the Ask a Question text box on your console. One CLE credit is approved for the webcast in California, Nebraska, New York, and Texas. CLE credit is pending in Illinois and Virginia. If you would like to receive CLE credit for this webcast, please download and submit the CLE sign-in sheet and evaluation forms. We will provide you with a confirmation code for you to enter on your sign-in sheet. I would now like to turn it over to Michael Bahar, partner and co-leader of Global Cybersecurity and Data Privacy at Eversheds Sutherland.
Thank you very much, and thank you very much to all of you for joining us today. Maybe if you only remember one thing about today, it is that you don't have to outrun the bear, only the slowest camper. I know it's a bit macabre, but the key takeaway is that as bad as the cyber threat is, and as tough the emerging regulatory environment is, at the end of the day, it's going to be about being reasonable, about being prudent. It's also going to be about knowing there are, in fact, a number of hungry bears out there, not just the attackers, but the regulators and the plaintiffs' bar, who are looking for that slowest camper or the fiduciary that is not doing what is needed to be prudent. Doesn't have to be perfect, only prudent. And that's what we're going to talk about today, knowing what to do to be prudent and having actual plans in place and a record that you are be proud to show to regulators and to courts to demonstrate that you are not, in fact, that slowest camper, that you are, in fact, prudent. My name is Michael Bahar. I'm a partner out of the Washington, D.C. office of Eversheds Sutherland, and I co-lead our global cybersecurity and data privacy practice. With me today is Allison Wheelabaugh. Allison?
Hi, everyone, and thanks, Michael. I am counsel in our employee benefits group here in Washington, and my practice involves compliance with ERISA from both the employer perspective and the retirement services industry perspective. I think I would start off by echoing something that Michael said, which is, in light of increasing cyber risk, escalating regulatory scrutiny, and the absence of significant judicial opinions or guidance from the federal agency that has enforcement jurisdiction over ERISA, which is the U.S. Department of Labor, fiduciaries need to fully understand the growing risks and responsibilities when it comes to cybersecurity and what to do about them. So Michael and I are going to discuss the privacy and data security landscapes, the potential fiduciary responsibility for securing employee data, and the steps that companies can take to mitigate their risks.
And before we begin, just another point on Allison. You were former Department of Labor, right?
Correct, yes.
So we actually have some inside, not information, but inside insights. And prior to coming to Eversheds Sutherland, I was also with the government. I was with the U.S. House of Representatives Intelligence Oversight Committee, doing a lot of cyber there. I was also the National Security Council with the White House and on active duty with the U.S. Navy. So hopefully we can share some insider insights as well. Alvin?
Thank you. So we all know that cybersecurity is important because of dynamic threats posed to our personal property by bad actors. We hear about it all the time, and the impacts are multi-layered and far-reaching. Today, the impacts we're focusing on provide the ERISA angle, the ERISA perspective, and so, we all, ERISA practitioners, will hear about the magnitude of wealth in retirement savings accounts and can understand why that would be an attractive target for bad actors, and hence this is why people are trying to get at those assets. But there are also less dramatic ways that fiduciary liability can creep in. For example, if required ERISA disclosures that are furnished electronically are not kept confidential, a plan could fail to meet some of its obligations that are a condition of fiduciary relief for investment selection, for example. So, I think of bad actors wanting to come in and get access to assets, which indeed is probably the case, would be the problem most of the time. But sometimes we have to also think about the sort of granular aspects of confidentiality breaches and how they can affect plan fiduciaries. So first, let's look at the fiduciary standard in our first bullet. Something quite familiar to many of you, I'm sure, that ERISA requires fiduciaries to act solely in the interests of participants and beneficiaries with the exclusive purpose of providing benefits to them. That's the I single towards plan participants. They are to carry out their duties prudently, and that's going to be the focus of our conversation today. Diversify investments, follow the plan documents, and pay reasonable expenses. These are all pretty well known. What is less well known is that fiduciaries are personally liable for breaches of their duties. And what does that mean? Well, there are sorted remedies depending on the type of claim made against the fiduciary. If it's the Department of Labor, the remedy would be a civil penalty and perhaps more. If we're talking about private plaintiffs, there's restitution and other equitable relief that are on the table. Note that ERISA expressly precludes indemnification of a fiduciary by the plan. So if you're personally liable and something happens and you end up owing damages, the plan cannot make you whole. The company, however, can indemnify. Last thing I'll mention in connection with this slide is that there are privacy requirements imposed on ERISA group health plans under HIPAA. So yet another regulator in play when it comes to personal information in connection with employee benefit plans. Indeed, uncertainty is risky, and it even feels riskier when nothing in ERISA really addresses cybersecurity. It doesn't explicitly require any special action to prevent privacy breaches, but it does require prudence. Well, what does that mean? Well, we're still waiting for the official word on that. There's no official regulatory or sub-regulatory guidance from DOL. All we really have is an ERISA Advisory Council report. Well, two reports. The first was issued in 2011 and the next in 2016. However, let me caveat this by saying that the ERISA Advisory Council really is a group of private citizens from assorted industries who advise the Labor Secretary and submit recommendations and reports. It's often a precedent for development of Labor Department policy and activity, but it doesn't hold any, it has no precedential value and is not an official action of the Labor Department. That said, it's being cited to a lot, and it has some good nuts and bolts in it. So I commend to you the 2016 Advisory Council report. In particular, it addresses cyber insurance and that sponsors and fiduciaries should understand what cyber insurance does and does not provide. And also addresses whether or not to incorporate cyber insurance and how to incorporate it into the risk management strategy.
Yeah, and in the sense that there is a lack of clarity and certainty from the Department of Labor and the regulators most on board, it's sometimes helpful to look at what other regulators are doing, and certainly regulators talk. And there is some emerging best practices, some emerging standards that are eventually going to come into play here. And that's what we're going to sort of look at and sort of divine what is likely going to be the standard of reasonableness before it becomes an issue. And perhaps one of the big takeaways is, again, hope is not a plan. So to the extent that there are folks out there who are hoping that there is no cybersecurity element in the conception of prudence, that in itself is probably not prudent. We need a plan. We need to figure out what we're going to be doing. We're going to want to document that plan. And throughout this presentation, we are going to talk about what exactly are the benchmarks of reasonableness and how that can be applied to prudence. And because hope is not a plan, the other thing that's important to realize is that instead you want to plan for the worst and hope for the best. And the worst case scenario is not a breach. As bad as breaches are, that is not the worst case scenario. The worst case scenario is the litigation, the regulatory enforcement action, the business interruption, and the reputational damage that comes with the breach that was poorly planned for. Right? And what we're going to focus on here are the first two prongs, the litigation risks and the regulatory enforcement risks that really need to be planned for, or we're getting in that 1-2 punch scenario when you get breached and then bam, you get punched again because then you're sued or you're the subject of regulatory enforcement action. So the key elements to being prudent is knowledge. And one of the things that you need to know out there is the threat landscape. And what's so important about this threat landscape is that it is getting worse. And that's not meant to scare, but it's meant to just acknowledge that everybody has to take up their game, because the threat is getting more pervasive and more determined, while at the same time not necessarily more sophisticated. And what I mean by that is, you know, people sometimes think you have to have this, you know, hacker with a hoodie in the basement of his mother's house, you know, clicking away. That's not really how it has to happen anymore. In fact, if you go onto the dark web, you yourself can pull down any number of hacking tools and deploy them against companies. That's pretty scary. It doesn't take a lot of ingenuity to do that. But on the other end of the spectrum are the geopolitical realities that you're seeing a lot more states out there with very advanced capabilities looking to play out their geopolitical disputes on companies, especially a lot of the companies that are iconic or global brands, many of which are, of course, represented here. And the last point I think people need to realize about the threat is most people, when they think about cyber threat, seem to think about theft of data, and of course that is very important. But the threat is morphing and evolving to not just exfiltration or theft of data, but actually extortion, right? Ransomware attacks, data manipulation, in the sense of subtly changing that data to say different things and maybe using that to embarrass a company or to engage in insider trading or to have larger macroeconomic effects. Cyber can now even be used to not only disrupt, but can even destroy, right? It can actually be used to take down companies. And again, the point of bringing this stuff all up is we need to go back to our plans and make sure, are we accounting for today's threats and tomorrow's threats, not just yesterday's threats.
So what can we say about what regulators are doing at the moment? Well, as Michael said, it's changing. The environment's changing, and regulators, our observation here is that the regulators are focused on proactive measures. It's about being reasonable. It seems to be the trend, and the regulators across sectors and jurisdictions are filling in what it means to be reasonable before a breach. And this is understandable if you think about it. It's tough to put the genie back in the bottle, as we like to say. And so focusing on prevention is a good place to focus. And then we also look at dealing with the problem once it's happened. But even though there's a large degree of regulatory convergence on what's reasonable, which could translate into what's prudent, there are important differences in requirements, especially reporting requirements across various jurisdictions. And I will also say there are, differences at the federal level versus state, and these are things we keep in mind. I mean, in the ERISA context, it's actually a good time to move on to the courts. Because in the ERISA context, we have ERISA preemption has played a role in some ERISA litigation regarding cybersecurity. In fact, we don't have many cases yet. And where ERISA comes up, it's where its case will be defended on the basis of ERISA preemption of state law that plaintiffs, under which state plaintiffs have made claims. And the cases we have seen show the importance of following process and controls. One of the more well-known ones, simply because of its magnitude, is the Anthem data breach litigation, which involved health plans, almost 80 million people were affected by this, and it's just the settlement is ongoing and active. And I think it's the class is still accepting members, if I'm not mistaken. But while courts don't seem to yet hold fiduciaries to a high standard regarding data privacy, what is prudent inevitably changes with time. And so as breaches become increasingly routine and therefore more a part of our consciousness, and perhaps more importantly, the consciousness of judges and agencies, standards for prudent protection of privacy may become stricter. The other case I've got on the slide I'll mention is interesting in that, in this case, an ex-spouse fraudulently took out funds from her ex's 401k plan account, and what had happened is that he didn't follow directions of the plan to change his mailing address when the marriage ended, and he didn't change his beneficiary designations or his passwords or pretty much anything. And his ex withdrew some money, a large amount from his account, and the plan defended on the basis that they followed the procedures that they had in place for keeping data and assets secure, and the plan won. They successfully defended on the basis that they followed their processes and procedures in making the disbursement from the participant's account. We expect to see more litigation, certainly coming down the road. It's almost inevitable, but we don't yet have a big breach case involving an ERISA plan that really sort of teases out the fiduciary's obligations.
And I think also one of the most important things that we can glean from litigation, as well as from what regulators are doing, is that prudence starts at the top. Leadership not only sets the tone, right? If you put, for example, cybersecurity on a board agenda, you can guarantee there'll be a lot of efforts to prepare for that board meeting, which of course filters all the way down to the organization. It's not just about that setting the tone, it's actually also about showing reasonableness and actually availing yourself of things like the business judgment rule. There is a case that because the board discussed cybersecurity periodically, the court awarded the business judgment rule, and therefore they didn't question anything, which is a great result. So even having it on a board agenda goes a long way to not being the slowest camper. But I think Allison's point is also that individual accountability at senior levels is becoming a regulatory reality. You can see that, for example, in the New York Department of Financial Services cybersecurity regulation, right? That requires senior sign-off, maybe even at the board level, actually sign off on the cybersecurity plans and programs. And for those of you, most of you out there who are lawyers, you can pretty much, and probably have already experienced this, that no senior executive, no board member is going to sign off on anything without having a legal review on it. So increasingly, that point of senior accountability is going to be driving outcomes as well. And the other important point is that cybersecurity is really mostly about people. It's not technology, right? No matter what you do, no matter how platinum level your cybersecurity is from a technological standpoint, any determined adversary, like a foreign nation, can get around it, or anybody can click on a phishing link despite your platinum level. And then that's a question about what are you going to do now that you have been breached. And the last point I'd make, too, is what leadership can do is not only give out responsibilities for cybersecurity, but actually make sure those who have that responsibility also have the authority to do something about it. So, for example, if we need to restart our systems to put a critical patch in, the C-suite and the board all backs that decision, says, yes, take down the network, institute the patch, then bring it back up, even though we know it's obviously going to cost us some time and some money. And because cybersecurity is not just about IT, the role of the lawyer is critical. Because again, if we go back to one of the earliest things we said, the worst case scenario is not the breach. As bad as the breach is, it's the litigation or the regulatory enforcement actions that happen with the breach that was poorly planned for and poorly sort of reacted to in the first few minutes of the breach. Therefore, it's really important to demonstrate prudence having a team. And core individuals from legal, IT, HR, especially if we're talking about private data and fiduciaries, crisis communications. We can talk about that a little bit later on, but saying the wrong thing in the first few minutes of the breach can be detrimental, right? If somebody goes out there and says, apologizes for what happened, what have they done? They've arguably assumed liability for it, right? That has made a bad day tragic. So having legal sign-off or legal to be joined at the hip with the CISO or the legal lawyer being the CISO, the Chief Information Security Officer, can help prevent those kind of early mistakes. And of course, that goes into what I was just talking about of who should be in charge. Again, there are many options. The key is making sure that people with the responsibility also have the necessary authority. Right? A lot of people are responsible for cybersecurity, but they actually lack that authority, and that's what you're going to have to demonstrate if you're breached. And the regulators or the plaintiff's bar come after you, they're going to want to know who was in charge and did that person have the sufficient authority. Companies with chief information security officers generally experience lower costs for incident response. Again, they're not required. Certain regulators, however, do require them. And it could really be anybody, but I think one of the big points is, and that we've seen in our practice, is that CISOs, or Chief Information Security Officers, generally should report outside of IT. Why is that? It's because IT, obviously, they have their own function. They're sufficiently busy doing what they do. But also, if they feel like they've been breached and it's their systems, there may be an element to try to not raise this up to senior levels, to not escalate quickly. And that's why it's also important to have somebody outside of that who doesn't maybe feel conflicted. And the CISO really is going to have to be a good communicator, going to have to understand the business and how the business uses technology to do business, and it's going to have that gravitas and the authority to compete for very limited resources.
Well, this sounds like what you're saying, Michael, is this affects the way financial companies do their business, conduct their business, but it also affects their people. You know, yeah. And when we're talking in the ERISA context, well, of course, we have service provider clients that work with ERISA plans, but we also have plan sponsor clients that run ERISA plans. So we care, and we're talking about both the security of data that's part of what a company does as its business, but also protecting the data of its own employees. And so part of the process is having a good plan and, knowing whom to call and how. And your lawyer needs to be engaged on all of these issues, particularly to preserve the option of privilege. It can be very important. And to make sure that any reports that are turned over read accurately, stick to the facts, and demonstrate reasonableness and prudence. And one other an important point I like to remember is that, high-tech problems can also have low-tech solutions. For example, a wallet card with key numbers you need to call. This is something I actually learned from Michael. If you think about it, if there's a catastrophic security breach, oftentimes what's the first place we all turn is our Outlook address box or Outlook emails. Well, if all that is unavailable, a good old-fashioned piece of paper is something that could prove to be invaluable when you're dealing with a breach.
Absolutely. In other words, prudence doesn't have to be expensive, right? A wallet card costs a couple of cents, but that is going to make the difference between a bad day and a tragic day. And increasingly, regulators are looking for that level of forethought. So for example, I think about a year ago, the SEC fined a broker-dealer investment advisor $1 million for a cybersecurity breach that caused no harm. Why? Because they didn't have the plans and procedures in place. So had that actually been worse, there was nothing that company was going to do about it. And that's, to your point, Allison, that increasing regulators are looking at what are you doing on the front end. They know that breaches are going to happen to everybody. Even doctors get sick. No matter how good your plan is, it could be breached. So how have you planned for it? And little things like that, which cost no money, make a huge difference. And, of course, if you have those numbers, then you can actually start to make those calls, activate your plans, actually bring down the overall cost of a breach anyway. So it's a win-win.
Right, and what you're saying, Michael, is really well established in ERISA jurisprudence. This notion that the process and prudence is almost more important than what the result is. For example, fiduciaries are often, claims made against fiduciaries by private plaintiffs will say, well, you chose bad investments for our plan. The plan ran large losses. Well, a loss doesn't necessarily mean that the fiduciary was imprudent. ERISA is looking for the care and forethought and thinking in acting on the fiduciary's part, and that's highly highly relevant in this context. In addition, we see it in this ERISA notion of Labor Department guidance that really highlights the fact that, look, in selecting a service provider, you don't need to go with in your spending plan money, you don't need the cheapest, you just lowest cost service provider, you can get the best and spend more money as long as you have investigated and done your homework about the service provider.
And as we all remember back to grade school, doing your homework largely means showing your math. They're less interested in the result, more interested in how you got there. Same thing with the regulators. So prudence is not only sort of knowing whom to call and how, it's knowing yourself. Know thyself is a central element of any prudent plan. It's also very important when you start going to data privacy, for those involved with GDPR, or eventually for the California Privacy Act. Knowing yourself is that first step. And that really just means taking an inventory. How sensitive is that data that you have? Where is that critical data stored and used? Who has access to it? Is it compartmented or segregated? What are the potential threats specific to you and your organization and your industry? And what are the potential consequences? Asking yourself those hard questions. What is your software development lifecycle plan, right? If you have one version and then it goes away and nobody's supporting it, are you keeping that same software there? If you are, then you're going to have vulnerabilities. You have to constantly have this continuous culture of knowing thyself and then taking that information and figuring out, okay, how am I going to tier my defenses to that specific data in a risk-based way? Again, so that you're not overspending the money. You don't want to be the fastest camper, but you don't want to be the slowest camper. You want to be right in the middle. You don't want to be overspending. So you want to create this layered defense. And once you determine what's your most special data, your most significant data, you protect that the most. And as you radiate outwards from that, you apply fewer and fewer defenses. And that's another way to be cost savings. Again, that's also an element of prudence. In addition to knowing yourself and knowing whom to call, you need to know your third parties. Right? You are your brother's keeper in this world, unfortunately. You cannot absolve yourselves of risk by passing off your personal data, your private data, your confidential data to others. You remain on the hook. If they touch your networks or hold your data, you need to understand their risks and vulnerability. That's a central tenet of things like Europe's General Data Protection Regulation, GDPR, which we just discussed, the New York Department of Financial Services, Cybersecurity Regulation. They're all requiring third-party accountability. And that goes with the previous slide of knowing yourself. Understand the data flows. Where is that data that you have being passed to? And if it's being passed to a third party, make sure to apportion risk the right way clearly in advance via contract. Who is going to be on the hook for that? Right? If you are GDPR compliant, you will know that you will have a data processing agreement or addendum in place that actually does that and lays out those responsibilities. You also want to consider other quality control mechanisms. Trust but verify. Audit rights, inspections, proof of any certifications like ISO certification, proof of cyber insurance. We'll talk about that a little bit later, but sometimes that's a proxy for a certain level of prudence, for having a level of care that is at least reasonable enough to be insured. This is a piece that is really worth taking a second to think about, because most people overlook third parties. They're so worried about themselves, they don't think about the third parties. But the famous Target hack, for example, that came in through the HVAC, the heating, ventilation, and cooling system. Right? Most breaches these days go through third parties. Why? Because you're not looking for that. They're trusted. It's a phishing campaign. Hey, I know this person. Let me click on the link. Boom, you just got hacked. Right? So really, take the time to not only know yourself, but know your third parties. That's going to be an element of prudence.
Specifically, let's talk about retirement plans and what sort of questions we want to be asking ourselves about our data security and our third parties, as Michael was just saying. First up, I want to make the comment that, something I see all the time is that, service providers to plans generally make a blanket statement, something on the order that they'll make a participant whole if a breach occurs. On the flip side, providers might be a little more rigid or limited about what constitutes a breach than others. I think my point is that, think about what these words mean. For example, if participants have not changed their passwords, or maybe they've given passwords to others, don't look at their quarterly statements, a service provider might be less likely to acknowledge that there was an error that they need to correct. And it's worth giving a thought to some of the policies and these specific terms to know exactly what you're getting. And also, understand what the indemnification policies are. But so helpfully, that ERISA Advisory Council report, I would direct you to for some great thinking on the questions regarding protection of data that would be helpful when you're contracting and evaluating service providers. So I just wanted to put that kernel in your head. But, service providers and plan sponsors, we can't emphasize this third-party point enough, and we want to make sure that they follow regulatory guidelines and industry standards, and certainly the contractual provisions. We want to understand if they've got a comprehensive and understandable security program, and what are its elements. How will the plan's data be maintained and protected? Will it be encrypted, at rest, in transit, on devices? And what's the extent of the liability the service provider would assume? We need to understand their indemnification policies as well. And, what are their protocols for notifying plan management in the case of a breach, and are the protocols satisfactory? Does the service provider regularly submit to voluntary external reviews of their controls? What's the level and type of financial and fraud coverage available to protect participants from financial damage? If we have a subcontractor, does the service provider insist on the same protections in its agreement with the subcontractors? For plan sponsors in particular, thinking about participant education is worth your time. Employees understanding their own responsibilities and rights and protecting their own personal information is important. In fact, usually problems in this area will develop because of human error. We want people to have good password protection practices. Also say the same for the handling of personal data by your HR department. In particular, how is data handled during transitions? That's a very important point. Do you have concentric, overlapping circles of authority and responsibility? Does the outgoing person train the incoming person? And you want them to be trained to recognize signs of misuse of data or fraud. So you want to have also, controls. Do you have controls in place over the physical assets that store sensitive data? This would be something to think about for your HR staff. So those steps and asking yourself, these questions can go a long way towards enhancing your security program. Another element is cyber insurance coverage, and to consider your own cyber insurance coverage. And it's actually a very important ERISA element, but you need to read your policy and know what your coverage provides. Increasingly, the insurance will provide greater predictability, and these are in unpredictable times. Sometimes it can also be a proxy for, adequate cybersecurity. Say, okay, well, if there's a breach, we have this insurance there backing us up. Know what insurance you have that would help defray the costs of a cyber incident. If you have the right insurance and you're dealing with a breach situation, it's going to go more smoothly. But you do need to take a look at it and understand exactly what you are paying for and what it will pay for when you run into problems.
Yeah, one of the biggest things you don't want to be dealing with in a breach situation is trying to figure out, am I covered? Wait, what? I have to go with this outside forensic company or this external counsel? No, I don't want to go with them. I want to use them. These are all the kind of things that you want to work out in advance. And to Allison's point earlier on know whom to call, if you are using external forensic consultants, right, make sure you have those privilege preserving documents in place beforehand, sometimes called a COVEL agreement, such that they are retained by external counsel, but in the same time are working directly for you. That's a great way to preserve privilege. But one of the first calls you're going to need to make is to your insurance company, because they're going to want to know, and they're going to want to make sure that you're spending what could be their money wisely. We're finding increasingly that people are surprised when they actually read their insurance coverage because they're not covered for what they think they are covered for.
Right, and a lot of the, I think this is a developing sort of area of insurance coverage, and yep. I think especially in some of the retirement plan services related contracts that cross my desk, the language is very boilerplate, and we're not at the stage yet where I think that plan sponsors and service providers are really tinkering with that language very much, but I do think it's going to be incumbent upon, from a prudence perspective, to really look at the language carefully, ask questions, find out what the words mean.
Right, and to your point, right, most cyber insurance is bespoke because they're just trying to figure this out, but sometimes they incorporate very boilerplate provisions. And unfortunately, a lot of those boilerplate provisions don't work very well in cyber. Just, for example, take force majeure, right? Basically, it says this insurance policy doesn't apply during acts of war, warlike activities, or terrorism. Think about some of the big breaches out there. They're from state sponsors or from terrorist groups. So arguably, an insurance company could say, hey, force majeure, we don't have to pay. Something to really look out for and to negotiate for in advance.
Indeed, I'd say in most of the contracts I've seen, less so recently, those force majeure clauses end up in this light looking like big gaping holes.
Yeah, because nobody reads them. Right? I recently, just because I read them, somebody put in a zombie apocalypse. Like, people are starting to put funny things in because they think nobody reads them, but there you go. All right, another thing is to know your regulatory and contractual notification requirements. Things during a breach are going to start happening very, very quickly. And it's going to be really important to have potentially a global regulatory strategy. And by that, I mean, so let's say if you get breached in New York, you're probably simultaneously getting breached in London, simultaneously getting breached in Singapore if you've got Asian operations. So you're going to have multiple regulators. Even if you're just breached in the United States, you could have states, you could have different federal regulatory agencies as well. And no regulator likes to read about it in the papers before they are notified. You have to understand this human element. So you want to, in a sense, create a chart that says, okay, I'm governed by New York DFS, I'm governed by the SEC, I'm governed by UK's ICO, the Hong Kong Monetary Authority, whatever it may be, and figure out what are those jurisdictional requirements, and then say, to be honest, I'm going to have to play to the fastest one. Right? If somebody has 48 and another one has 72, in reality, you've got 48. Because, again, no regulator wants to read about it in tomorrow's paper. And you want to provide a consistent, if not hopefully identical message to all those regulators. That's very important. But, again, at time zero is not when you want to be working that out. You know, for example, that's why we created an app, right? Also to your point that if you keep all these plans on a computer and if your computer is locked up in a ransomware attack, it's not going to do you any good. So in addition to printing things out, we've developed an app, right? So you can say, okay, here is the GDPR requirements, here's the New York requirements, here's the Montana requirements, here's Japan's requirements. Wherever it is, you have your notification requirements right there. But also it's really important, and especially for the most junior lawyers who are just working on contracts, they too have a huge role to play in cybersecurity. Because, for example, if they agree to a contractual notification requirement of, let's say, 24 hours, and you otherwise would have 72 hours under Europe's GDPR to notify in a breach, in effect, you've just dropped your notification timeline down to 24 hours. Because as soon as you give it over to a third party, you can just assume that that cat's going to be out of the bag. And again, no regulator wants to read about it in the paper. You want to be really careful and know what your contractual reporting obligations are and make sure not to make them too short, otherwise you bind your hand.
So Michael mentioned an app, and I think if it wasn't clear, he was talking about an app that he and others here at Eversheds created. And so I'm thinking maybe if audience members would like to find the app and download it, how can they do that?
Yeah, it's called Breach Law Watch app, and we can certainly send that out. I know a number of you asked whether we're going to be making the slides available. Yes, we are certainly making the slides available. And while we're on the question of questions, we noticed somebody was asking about, is live testing a key element for a program that regulators will regard favorably? Absolutely. Testing and practicing are key. In fact, an element of prudence is practice, 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 and documenting the fact that you are practicing. So we say at least annually. And a lot of companies have disaster recovery or business continuity plans. However, not many of these plans address cyber incidents directly, which could present unique facets, especially because cyber is insidious at times. Right? The average time between an attack and when you actually know it is 273 days. It's very different than an earthquake or some other type of natural disaster. Right? This has been creepy in a while, and a lot of times somebody had noticed it, but they didn't escalate it. Right? So you want to test these plans, and again, live testing is so important because once you test, then you refine. Once you test, then you refine, and you can that makes sure you have that continuous culture of cybersecurity that we were talking about that is emerging as being prudent. And as we've been saying, this regulatory enforcement and litigation preparedness is central to a sound plan. And you want to practice that at the end of the day, people know what to do, whom to call, to Allison's point, and what needs to change in the plan.
Actually, I would say that a principle of the ERISA fiduciary's role is that this idea, going back to what the statutory language that talks about, what do we have here? Acting, carry out their duties prudently. We have a lot of precedent saying, a prudent fiduciary knows its own limits. And so part of ERISA prudence is going to that third-party service provider, the outside expert that really knows its business and will help you develop your policy. So that is certainly from an ERISA perspective, that level of preparedness is what we hope for, the prudent expert. So, employee training, this is something I mentioned earlier, and ask yourself when you've got transitions between employees, I think primarily of an HR department because of the employee benefits angle I'm focused on, but this can be anywhere. Of course, this would be in your IT also. And that's the other sort of internal complication. It ought to be clear when there's a breach concerning just the employee benefits plan, you want to be sure you know who is going to step in there. Is it going to be your HR staff, or is it the IT staff's job, or a combination? That's certainly an easy box to check and something you want to be clear about as you make preparations. And you want to avoid, single points of failure. A single person can be the weak link, and that's often exploited. Employees also ought to know, I think actually I'm just finally getting better at this, at recognizing phishing and spam email and what to do when they spot one. And I think part of this is because our IT department here is pretty direct in letting us know what to look for, and also really encourages their involvement, for any reason, because, the sort of ounce of prevention attitude is really important.
I think it's also important that, you say even if you get your own house in order, and we'll talk about in the next slide about using things like dual-factor authentication to sort of help prevent against phishing attacks, a lot of times what we're seeing is that a third party is attacked via phishing, then they send you a fake invoice, and either you pay it thinking it's going to the person you're supposed to, but it's going to someplace else in Nigeria. For whatever reason, it always seems to be in Nigeria. But how to spot those? And a lot of times we're also getting the heroes, the HR employees, and they're like, hey, I see this is a problem. They elevate it, and boom, it finds out that we stopped that $60,000 payment. And we were able to inform the other party, hey, by the way, you've been breached. Although sometimes it's not. And that's why it is important to have an element of technical benchmarking in your prudence. Because increasingly we are seeing certain types of technological, quote-unquote, solutions becoming minimum standards. I put solutions in quotes because there is, again, no 100% solution. But there are certain things that so many people are doing after a breach that increasingly that's going to become the standard before the breach. And this is so even though regulations are wisely being drafted as tech neutral, right, because the technology is changing so rapidly. But yes, I mean, if everybody is allowed to have the same password, especially administrators, and believe me, we've seen this, that's not good. That looks really, really bad. If they're allowed to have password 123 as their password, that's really bad too. And speaking of password, let me give you the CLE confirmation code, which might as well be BEAR, B-E-A-R. So you can put that in and make sure you get your CLE, but don't use that as your password now. The other is multi-factor authentication. That's what we were talking about. Sometimes having an external token. So even if they have your username and password, which are really easy to get, they still won't be able to successfully log on. Other examples are encryption data at rest. A little bit more difficult encrypting data in motion, but data at rest is increasingly becoming the expectation. For example, in New York DFS, it is strongly encouraged. In HIPAA, if you're subject to that, you can avail yourself of the safe harbor provisions if you're appropriately encrypted. Patch policies are really important. We've seen some high-profile breaches. And this goes to Allison's point and the point we've been making. It's about not being perfect, but about being reasonable. So if you, for example, have to update your software and you have a patch policy which you followed, and let's say that patch policy says for this level of vulnerability, we're going to do it Saturdays or Sundays, and you get breached on a Friday, hey, you were reasonable. That's fine. You followed your plan. If it's a critical vulnerability, yes, those are the times when you need to take down your systems. You make sure you have your board or C-suite backing the responsibility plus authority to bring down the system to patch it right away. But otherwise, if you are following your patch policies and you get breached, hey, sometimes that happens. You're not going to get that 1-2 punch of then getting successfully sued or having regulatory enforcement. And the other thing that we're seeing a lot with HR in particular is policies on how to handle PII or PHI or any type of personal data. Maybe not allowing that to be emailed around in unencrypted form. Maybe having locked storage or cover sheets, all those types of practices, and having all those practices documented. somebody undoubtedly will mess up and send something without thinking at Friday at 4:59 trying to get out, and that's when the breach occurs. Okay, but if you can point back to the policy and the training on that policy, you will avoid that 1-2 punch, and you will not be the slowest camper.
Can you talk about what you mean by tech neutral for a moment? And what I'm thinking is that, the government is hampered by itself here.
Mm-hmm.
It takes a long time to get laws passed. It takes a long time to write regs. By the time a notice and comment period is passed and a reg is finalized, the cyber landscape probably will change. Is that what you're talking about here? So
Exactly. And that at times can be frustrating to companies because they're like, just tell me what to do and we'll do it. But that's not the way cyber and privacy regulations are going to be, because, as you say, as soon as the ink is dry eventually on this process of rulemaking or legislation, the technology will be outdated. So that's why if you look at things like Europe's GDPR, it says you must have appropriate technical and organizational measures, to secure the data. Or if you look at New York's Department of Financial Services, they're talking about risk-based assessment and risk-based approach. Same idea. You want to be, the regulation is going to be tech neutral, but that means it's incumbent on you to be up with the times. And that's why I wanted to mention these, because I keep putting them in for clients as here are the lessons we've learned after our breach. So I know others are doing that, and eventually that's going to be the pre-requirements as well.
And I have to say that, I fall back on this idea, well, the Labor Department hasn't said anything. Well, courts, Labor Department is not going to give us much when they finally do say something, because, ERISA is about reasonableness, and they never say what's reasonable. A lot of times when I was there, we would hear just exactly what you said, service providers saying, look, we want to comply. Tell us what to do. They won't. They're going to look to reasonableness and say what is reasonable will depend on the facts and circumstances you've got in front of you. So while it would be nice that if they would say something, give us something to go on, I'm not optimistic that it will be much.
Right. And to go to some of the questions we actually have on this issue is what steps can ERISA fiduciary take to ensure there's no impermissible screen scraping of plan data? I think that might be subdivided as screen grabbing, which is, taking a picture of it or printing it out, or scraping of the data, which is going not necessarily behind it, actually just pulling or downloading a lot of data. I think there's probably a couple answers to that. One, what we've seen, certainly in the government, is disabling thumb drives, right? Not having anybody have the ability to put in a thumb drive, which is not only good for introducing viruses, but also for exfiltration of data from that insider threat. The other is using thin clients, so there's a limit to how much information is accessible. But of course, at the end of the day, the hardest, as you mentioned in your slide, we have met the enemy and he is us. That often the insider threat is the most difficult to defend against, because of course we in the former in the government know very well that some of the most high-profile attacks have been by insiders. Others have moved to insider threat monitoring detection. So if people are doing unusual things like, print screening a lot, or printing a lot, or they're late at night, those type of anomalous behaviors are flagged. Of course, if you're also GDPR compliant, you'll probably want to do the data privacy impact assessment on that. But again, that goes to the point of showing your math, because most likely that it will be considered reasonable. As long as there's some notice and transparency around it, because you are trying to protect valuable information, which is, of course, also good. And encryption, yes, we have another question on encryption and encryption at rest. Look, again, if you encrypt things at rest and the bad guys get in through some means and they exfil the data, it'll just be gobbledygook, right? If they are able to get legitimate credentials, username and password, then they're probably able to go behind that and actually see it in unencrypted form. So that's why something like dual-factor authentication would help. So again, the attackers come in on multiple vectors, and that's why we go back to that know thyself, figure out what they do have, what are the vectors, what are the threats, and layering that defense around it, because there's no one solution. That's, again, why we put it in quotation marks. So we're nearing the end of our time, so we thought we would take the next couple of minutes and wrap up. Remember, the CLE code is BEAR. Hope is not a plan. This is huge. Hope is not a plan. You'd be amazed how many companies hope for things. Instead, you want to plan for the worst and hope for the best. And the worst case scenario is not the breach. It's the litigation, the regulatory enforcement, the reputational damage, and the business interruption that comes from a breach that wasn't really planned for well. And therefore, at time zero, the execution wasn't good.
The other takeaway, or another takeaway, is that thinking about this, working on it, taking steps, making a plan, these things indicate prudence, or the lack thereof, depending on the quality of all of that. But it's, it's time to act is now, really. And lawyers need to be involved early and often, we think. We don't want you thinking of this as solely an IT issue or an HR issue. Thinking about cybersecurity really should be part of an overall legal strategy and addressing the risks associated with it.
Yeah, lawyers really make the difference between a bad day and a tragic day when it comes to cybersecurity. Right? The IT folks are at the front end, they're doing their best, but when it happens, the difference between that bad day and the tragic day, the 1-2 punch is going to be largely in the role of the lawyer, making sure things like privilege are accounted for, making sure to write a favorable record of reasonableness to show prudence, right, to show that why you did this and not that, why you don't have to be perfect, right, you just have to be reasonable. And another key takeaway is prudence requires knowledge. A lot of people, again, with this hope being their plan, they hide their head in the sand. But you have to lift your head up and say, okay, what are the evolving threats? Not just the current threats, you have to anticipate the future threats. Not the same thing for the regulations. What are the existing regulations and what are the evolving regulations? Especially because they are tech neutral, they are going to be evolving. Because they are risk-based, they are going to evolve as the risks and the threats evolve. Understand what is reasonableness. Understand what are others in your industry and others in your area doing. Know yourself and know your third parties. That's what most people fall down on, and that's what the attackers know. That's what the regulators are looking for. So that's what we want to really impress upon you here.
And my favorite is that high-tech problems can have low-tech solutions, and keep a wallet card, keep a piece of paper. I once, a client told me that their HR director carried a piece of loose leaf paper in his car folded in the back of the driver's seat that had everything he needed on it. I said, that's great. Avoid single points of failure. Train your employees. As we've discussed, the problems here often arise out from a single actor, so keep training.
And as we said, you don't have to outrun the bear, only the slowest camper. It's easy to get overwhelmed by the threats, by the regulations, but you don't have to be perfect. You just got to be reasonable. You just got to be prudent. And a lot of times prudence is what you say it is. It's how you write it and keeping up with the Joneses. So with that, we're at the top of the hour. Thank you all very much. We really appreciate your time. We hope you found this very helpful. Thank you.
Ladies and gentlemen, this does conclude today's webcast. You may disconnect your lines at this time, and have a wonderful day.